So thank you again, everybody, so much for joining, and I hope that you are excited to learn how you can both protect your wealth and save thousands in taxes at the same time. And that's what we're going to cover today. We're going to cover some of our most common mistakes that we see real estate investors make, and we'll even pull the curtain back to one of our favorite strategies related to a specific kind of trust that most other people don't use or haven't thought about. It's something unique to us and that we have tested and proven and have seen work over and over again. So we're excited to be here tonight. Just a quick introduction to us as a law firm. So we are Anderson Business Advisors. We are a law firm, and yes, we are attorneys. We're based out of Las Vegas, Nevada. And so, yes, I am an attorney. I went to law school, both fortunately and unfortunately. So, well, I'll cover more about myself in a minute, but I did want to go over a couple of things about us as a firm. So you can see here that we are, again, like I said, we're a law firm and we are attorneys. However, we like to think of ourselves more as an education company rather than a law firm. We pride ourselves at Anderson Advisors in being non-traditional because we ourselves come from a background of being investors, being traders on the stock market, real estate investors and owners, as well as small business owners ourselves who happen to have degrees from law school. In fact, our founding partners, Clint Coons and Toby Mathis, who, if you go to that summit, either I almost said later this month. It's not quite November yet, but here in a couple weeks, or in December, you'll get to hear them speak as well, talk about their stories. But our founding partners, pardon, Clint Coons and Toby Mathis, they got their start beginning Anderson and sort of the way that we do things because of their experience investing. Not because of their experience in law school, but because of their experience first trading on the stock market, and then after that, buying their first investment in rental properties. And realizing the things that investors go through and that they could leverage their education as attorneys to help themselves and other investors out. And so we believe strongly, I realize it's a little cliche to say, but we believe strongly in giving back to the community of investors so that you don't have to go through the pains of law school in order to know what we know, or the pains of the experience that we've had. Not every investment goes perfectly, and you know that, but we come at this as an angle of investors who happen to be legally educated rather than lawyers who maybe only experience things in theory, or who have book learning but have never been in your shoes as investors. So that's very important, and we take pride in that. As well, when we talk about these strategies, I want to emphasize that it's because we have engaged in them too. So we'll talk about using LLCs and trusts and other tax planning strategies, again, to both protect your assets and save on taxes while you're doing it. And we've tested out these strategies ourselves. You'll see here that not only are we a law firm, but we have CPAs, we have tax preparers and tax planners in-house. Yes, we can prepare your taxes for you if you like. And we have tested some of these tax strategies that I'm going to tell you about later. We have tested them in audit, and yes, some of them even in tax court. And we've come out on top. And this is important because it's not just the theory of the strategies, but it's our experience that brings these ideas into reality. We know not just what the IRS code says, but we know how auditors look at it. We know what auditors pay attention for. We know what flies and what doesn't before the tax court, and we leverage all of this so that you can take advantage of it. And this is very important as well when we talk about protecting your wealth, about asset protection. We are also attorneys. We've been through this. I'll tell you more about my background here in just a second, but I was a litigator, so I've seen how these strategies work, which ones do and which ones don't in court. And so we bring all that here in house. And yes, we even do estate planning and living trusts as well. So when you think about your legacy, not just what you're building now, but also what you are going to pass on after you're done to your children or friends or family members or even charitable organizations, whatever it is that you may decide, so that you control what happens to all of it. And so tonight, then we are going to cover a couple of basic principles, both of protection, asset protection, and tax planning, so that we can then pull back the curtain and go over a couple of advanced strategies that you may not have heard of, and that candidly most CPAs haven't heard of either, so that you can save on taxes and you can make sure you're protected. So thank you again so much for joining us. I'll give you a quick introduction to myself and then we'll dive right in. So again, my name is Jeff Cottle. I'm one of the senior attorneys here at Anderson Business Advisors. I've been with Anderson for a few years now, but I did have really good experience as an attorney before coming here. I won't say how many years, but I will say it's more than you think. I had somebody allege that I'm only 28 years old a couple months ago. Boy, that was simultaneously a compliment and an insult. I promise you I'm much older than that, and I have plenty of years of experience as an attorney under my belt. I come from a more traditional law firm background before coming to Anderson. I was a litigator. I did my time with what they call motion practice, right, in big complicated cases that with several parties where I'm going toe to toe. It's actually really funny. The law firm where I was at before coming to Anderson was rather small. I was one of only a small handful of attorneys there, and we represented a lot of actually really high net worth business clients. And this was kind of a funny juxtaposition because a couple of times I found myself at the time as a younger attorney going up against senior partners at the biggest law firms in the near metropolitan area, right? Who have been practicing for decades, and here I am going toe to toe with them. I'll be honest, it's simultaneously true that I did not enjoy that lifestyle, but I was really good at it. And so it taught me some things early in my career that most attorneys don't get the chance to experience until they're much further along. And I got to see how the world of these lawsuits and how the big shot attorneys work in practice long beforehand. And in fact, let me tell you, I had a client, so this will dive in and this will get into one of our first principles that we want to talk about tonight. And again, we'll go over some baseline principles. Some of you are probably familiar with these, but I want us to have a good base knowledge so that we can all learn together when we get to the more advanced things. So some of this may be review for a few of you, but I want to make sure we're all operating from the same baseline when we get to the more advanced and more fun strategies. So I'll tell you a story of one of my clients to illustrate the first principle I want to talk about. So one of my clients, before I came here to Anderson, was a very wealthy business owner who was also a real estate investor. And he had a lot going for him. He was very well known in his specific industry. Obviously, for confidentiality reasons, I can't tell you too many details, but he was very well known within his sphere. He wasn't like a true internet celebrity, but within his sphere, everybody knew who he was. And he had one big sort of hiccup to his setup, and that was that he did everything in his personal name. All of his business accounts, all of his investments were under his name, and this included, specific to the case that I worked on with him, this included a very valuable piece of real estate. So what happened was, unfortunately, somebody thought they had a claim against him. It was a pretty bogus claim, but they took this to a plaintiff's attorney. This plaintiff's attorney, I'm obviously paraphrasing a little bit here, he saw instantly that this, my client, was a target. Could look him up on the internet and could see not only that he was a small to medium-ish celebrity, but also he could see all of his investments right there so easily. And so what this attorney did is he filed a lawsuit right away, and he got from the court, I'm going to use one of those Latin terms that I really hate, but I'll explain what it is. He got a preliminary injunction from the court, which basically allowed him to freeze up all of my client's accounts and put what is called a lis pendens, basically a do not touch sign, on my client's real estate without going through a full lawsuit. It was wild. This all happened before I came onto the case, but my client went overnight from being a wealthy business owner with many investments to his name to living off of his mother with his kids in an instant. And so then I came on after the fact. I was able to convince the judge to walk back a couple things, which is which for those of you who know, it's a very big deal to convince a judge to change their mind on anything. So I was a little proud of that, but unfortunately, most of the damage had already been done at that stage. So then my client's life was turned upside down in almost an instant, and the primary reason was because just about everything was in his personal name. And so that is going to be the first thing that I talk with you about tonight is that attorneys do not operate on truth and justice and right. And any attorney, any attorney, excuse me, any attorney will tell you the same thing, that attorneys do not operate on truth and justice and right or righteousness anymore. They operate on money. And that's just how it works. So if you look like you have money, whether or not that's actually true, if you look like you have money, then you become a target. And so the first thing I'm going to tell you is do not do what my client did. And yes, I did open up with that story for a purpose. It's because it illustrates the first principle that I want to talk about here, which is do not do what he did. Instead, do not invest in your personal name. That's the first thing I will tell anybody who says, hey, Jeff, what's your first tip for real estate investors who are getting started? Or candidly, I'll say this to anyone who is further along as well, is do not invest in your personal name. We actually usually recommend LLCs. There's a space for trusts, don't worry. I'll tell you exactly one of those most important strategies for trusts here in a little bit. But the very first thing that we want to do is say do not invest in your personal name. Do not be like my client from earlier in my career and have everything in your personal name and then have just one action go wrong and suddenly everything's gone. Invest instead for real estate very frequently, not always, but very frequently, we'll start with LLCs. LLC literally stands for limited liability company. Now, why is this? Why do we say, hey, do not invest in your personal name? The reason for this is twofold, actually. So there are two primary reasons. The first, again, is avoiding that target on your back. If my wife and I purchase a property just down the street, if the county records, if we purchase it in our own names, the county records will say Jeff and Malia Cottle own this property. And anybody can search that and look it up. This is problematic because when a plaintiff or somebody who wants to start a lawsuit walks into an attorney's office, the first thing that this attorney will ask is not, do you have any damages? It's not, do you have any, I don't know, medical bills? Have you missed any work? First question they ask is not, can you prove to me that something went wrong here? No, 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 no. The first thing any good attorney asks is, who is the other party? Why do they ask that first? Because the attorney wants to get paid. And so if they look up the other party and they see your name on 3, 4, 5, 6, 7 pieces of real estate, they say the lawsuit is coming, no matter what. Why? Because you have money and the attorneys want to get paid. Now, you may not think you have money. These properties may be leveraged. We may be, property rich and cash poor. It doesn't matter because you look like you have money if your name is slapped all over the county records. So that's the important thing we want to start with is say, hey, let's not, if you're a real estate investor, let's not put your name all over the county records. Let's not advertise that you're an investor. Instead, use an LLC. This way, the LLC name shows up on the county records instead of your name. And honestly, that is the first and most important mistake that we see the wealthy and real estate investors making is they say, hey, look, I understand that it's probably good to invest using a trust or an LLC in some point, but I'm just going to invest in my personal name for now. Now, sometimes if you come up on a deal and you need to make something happen fast, maybe that makes sense for the moment. But the problem then becomes is, well, cat's out of the bag. Your name's on the county records now. And we need to change that as quickly as we can. So instead, put the LLC on the county record. So that's the first principle we're talking about tonight is, hey, do not invest in your personal name. Use something else instead. Usually LLCs, but I'll tell you where trusts come in. They're really important here in just a minute. The second reason, though, the LLCs are so vital and the right kind of trust. That's why we talk about using them the right way. But the second reason why LLCs and the right kind of trust are really important is because not only do they take that target off your back, but they protect you during a lawsuit as well. Even if somebody does discover that you own the LLC. LLC literally stands for Limited Liability Company. So the LLC then caps the liability. If somebody has a slip and fall on your property, they're going to sue the owner of the property. And if that owner is you, that might be trouble. But if the owner of that property is instead, say, oh, I don't know, the 123 Main Street LLC, then the other party is now suing the 123 Main Street LLC. And importantly, they are not suing you. And they actually cannot sue you. They may try, but then your attorney immediately files a motion to dismiss, and that's one of the easiest motions a judge will ever grant. You don't own the property, the LLC does. So this is really important because that LLC caps that liability, makes it so that you cannot be sued in anything related to the property. Just as important, though, is the reverse. If something happens to you personally, let's say you're in a car accident or something like that, or even worse, a child of yours is, then the LLC cannot be sued. Why? Because you were driving the car. The LLC wasn't behind the wheel. And so this way, you get that protection going both ways. You are protected from your property, and your property is protected from you. If this, my client that we talked about towards the beginning here, if he had had his business in an LLC, none of that mess up would have happened for his life. Even better, if he had had his real estate, again, this is a very valuable property worth several $1,000,000. If he had had that in an LLC, especially in a good structure with a parent or a holding company in a state that provides good protection, it would have never even been dreamt of being touched in that lawsuit. It's so far away from being possible. But because he invested in his personal name, everything was gone in an instant. So that is the first key principle. And again, we recommend LLCs because they take that target off your back and because they provide actual protection in court. So that's that first basic principle. You'll see there on the other side here that we do also talk about tax planning. So we'll recommend using corporate entities to save on taxes too. And it's all part of a holistic structure. And I'm going to take a pause here for just a second to emphasize that big principle there that Kendall spoke about towards the beginning. Is that when we talk about these strategies tonight, some of them may be applicable to you, but some of them won't. And that's why it's important to realize that there is no one magic bullet. The biggest value that any attorney can provide, even if it's not me, right? Even if you're talking with somebody else, but the biggest value they can provide is not that they file an LLC for you. No, Legal Doom can do that. Sorry, Legal Zoom. but much more that they make sure that you have the right strategy and you're using the right things for your situation. So I'll get to something that's really important here that you'll see come up, especially if you talk with us, is that not only do we recommend using LLCs to invest in real estate, But then we'll also, I'm going to skip a page here and we'll talk about trust here in just a second. But then we'll also clarify here that not all LLCs are created equal. LLCs in some states provide far better protection than others. And so you'll see that we will talk about this parent and child company principle here, or sometimes you can call it a holding company instead. And so we have that holding company that acts as a shield or a protector or a castle or an umbrella, whatever other metaphor you want to use there. So that holding company then provides protection for the other LLCs that actually own the real estate. So if you are investing in, say, I'm just going to use an example here. If you're investing in Texas, you may have Texas LLCs up here that own your property directly. And then those Texas LLCs will then be owned by your Wyoming LLC. So what happens then, and yes, you see the Wyoming LLC is the parent company. To be clear, we don't always recommend Wyoming, but Wyoming is most common for our real estate investors. So that Wyoming parent company then will provide protection for LLCs that may be formed in other states where you have a little bit less protection. So the way that this works, and the reason we choose Wyoming is because I want to be clear that any LLC in any state is better than nothing, right? Even using a, heaven forbid, a California LLC is better than investing using your personal name. Absolutely, absolutely. But then we take it one step further and we say, okay, but even then, some LLCs are better than others. And so Wyoming is just better for our real estate investors. I'll tell you why. Is because Wyoming statutes are as clear as is humanly possible. And they obviously they speak in a little more legalese than this, but I'll tell you the Wyoming statutes they say functionally nobody can ever by all that is holy even think about maybe considering possibly taking anything out of a Wyoming LLC. Now, again, they say that in a more legalese sense, but that's what it says. And even better is that in Wyoming, they go even further. And they say not only can you never take anything out of an LLC, but the Wyoming legislature even then went so far as to list out things that have happened in other states and then spell them out and say these cannot happen here. So Wyoming not only says you could never take anything out of an LLC, but then Wyoming goes further and says you can also not take management control over an LLC. You cannot force distributions out of an LLC. You cannot, pardon me, you cannot foreclose on an ownership interest in an LLC. So it goes through and lists these things out and says, nuh-uh, no way, not here. And so Wyoming goes as far as they possibly can for asset protection in their LLC statute. So that's the first reason. A couple others are that Wyoming also has judges, has a judiciary branch that, at least to this point, has respected the legislature and everything that they've done. This is not the case in all 50 states. Florida, ironically enough, the two polar opposite corners of the country, Florida and Oregon, both have cases where their Supreme Court actually went against what the legislature said. In fact, in Florida in particular, the Florida Supreme Court went so far to say, acknowledge, hey, we know what the legislature said, but we don't actually think they meant that. Like they went so far as to acknowledge that they were actively going against what the legislature said. It's kind of wild. And so, anyways, point being though is that in Wyoming they don't do that. We have judges that have respected the legislature and the statutes on the books. As well in Wyoming, we have what's called anonymity, where your ownership interest in the Wyoming LLC will never be made known public because Wyoming doesn't ask for that information. Wyoming doesn't know who owns the LLCs, and we love that. We don't tell them. And so if we file a Wyoming LLC for you, you become anonymous. Nobody can know of or prove your ownership. Or at least not through traditional means, right? If they get a subpoena from a judge, then sure you disclose it, but then you say, so what? They can't do anything about it. And that's great. That's what we want. So that that's why Wyoming. Last thing is honestly Wyoming's a little less expensive than a couple of the other states that have decent protection like Nevada or Delaware. So Wyoming parent company then holds other LLCs. And I did want to see here. I saw that somebody asked here. Scott asks, and forgive me for looking off screen. I do have my Q&A and the chat pulled up over here on the other monitor. So please feel free to send in questions as we're going. Scott asks and says, "Okay, well, what do we need to do then to keep a Wyoming LLC valid, or to make sure that it is in good standing so that it cannot be pierced in a lawsuit?" And Scott, that's a great question. There are a couple of simple answers to that. And the first being that you have to make sure you file your annual renewals, right? Make sure it's in good standing with the state. So in Wyoming, for example, your annual renewal is it's some oddly specific number. I want to say it's like $62.25, something like that, per year that you pay to the state of Wyoming to have your Wyoming LLC in place. So that's the first thing is you file your renewals. But the second thing that's really important when you have an LLC, and I realize this is going to be vague, but it is important, and it's come up in court over and over and over again, is that you treat your LLC like a business. Because that's ultimately what it is. It's a limited liability company. And so what a judge or a court, pardon, is going to look for is they're going to see if you actively treated your LLC like a business. Did you have your own business banking account? Did you keep your business banking account separate from your personal one? Did you use that LLC, say for example, to enter into contracts with contractors or with groundskeepers or with a management company or with your tenants? Did you act like the LLC was actually a business and very importantly, that it's an active business that owns your property? If you did, yeah, it's as close to impenetrable as it gets. Now, if you didn't, even then you still have protection, but you've allowed another attorney to get their big toe in the door. In fact, this actually came up. I'll use an example here where this was a few years ago. This was a case it was out of Utah and California. It had facts and circumstances related to both. But this ultimately, what came down to this person who was being sued, the judge functionally said, "I would not have been able to break into this LLC at all, but for the fact that the person being sued used it for personal reasons. He used it to buy boats for himself. He completely ignored his own operating agreement. That was actually a big deal in the facts of that case, is that he completely ignored his own operating agreement and went absolutely against his own operating agreement and some of the things that he did. And so he wasn't treating it like a business. And the judge, again, said it in more legalese, but basically said, like, I wouldn't have been able to touch anything in this LLC if he had actually taken care of it. But because he didn't take care of it and did these couple things, and he cited to a couple things that the person did, I'm allowing the plaintiff to break into the LLC. And this was even with a Utah LLC. Utah is not known for good protection. So imagine in Wyoming where we do have good protection. In fact, I'll summarize this story for you. I could go into a lot more detail, but we had one client in particular who did have a Wyoming LLC who lost a lawsuit, he got a judgment against him. Now, it was a very silly lawsuit because the state in question, I won't mention California by name, had made a statute retroactive. So our client had actually been obeying the statute at the time, but then California says, we're changing our minds for the past. It was ridiculous. But anyways, point being is he lost a lawsuit then because of it, even though it was patently unfair. But his assets were all in a Wyoming LLC. So even though the other party had won the lawsuit, they actually couldn't have access to anything. He literally lost the lawsuit, but still didn't end up having to pay. So it was pretty incredible how that works. I mean, that's because it was in good standing and he had taken care of that LLC. So again, these are how LLCs work and how they provide protection here. And so that's going to be again our first big principle of asset protection and protecting your wealth is do not invest in your personal name. I'll tell you about a couple of the principles of tax planning, and then, as we promised, I'll talk about the trusts and how we use them here in just a second. I did see another question come in here, so I'm going to take half a second and read over it here. All right. So this question does get a little specific here. So So this question Bob asks, and so I'm going to respond to this very generally because it does get a little specific into tax planning, and I'll go ahead and I'll use this as a springboard to talk about tax planning. So Bob asks functionally, hey, if I have depreciated or lowered, some of you may be familiar with the term basis, right? Basis is a term in tax planning for what you use to calculate how much taxes you owe. Higher basis, you pay less in taxes when you sell an asset. If you lower your basis, you pay more in taxes, at least in theory, when an individual sells the asset. Now, Bob asks, hey, if I contribute an asset with a really low basis to a charitable organization, does that charitable organization have to deal with that low basis and the potential tax problems that come with it? And the answer is usually no. So, Bob, I'm not going to be able to address your specific situation without knowing more about it. But I'll tell you generally, the charitable organization does not keep your basis when you contribute it, when you make a donation here. Instead, the charitable organization gets to take the basis at the fair market value when you make the contribution. So this becomes a very powerful tool if you say bought Apple stock in the early 2000s and suddenly you're sitting on a ginormous amount of wealth there, but potentially also a equally ginormous amount of taxes that you might have to pay if you sell that stock. So there are some people who will use that then to donate it to a charitable organization in order to have sort of a workaround for the taxes. I say sort of a workaround because the big drawback to donating to a charitable organization is that it's not yours anymore. It belongs to the charity. And so for some people that's okay and makes a lot of sense. But that's kind of the caution that I have to tell clients when we talk about this is, hey, let's just make sure we understand here that it's not your asset anymore. It belongs to the charity and it has to be used for charitable purposes. And for a lot of people, that's just fine. In fact, they still love that idea, and that's great. But it's just something we need to clarify there. So, good question there, Bob. So, I do want to address briefly, and then I'll grab a couple of these other questions here. I do want to address briefly a couple of principles of tax planning, and I want to go ahead and actually just draw it out here. So when we talk about tax planning, that's actually the first principle of taxes that I want to tell you about is it's not tax preparing, it is tax planning. Some of you have worked with, I'm sure, and in fact, many of us have worked with somebody who is what we would call loosely a tax preparer. Somebody who prepares and files your taxes, but doesn't really ask questions or put together a plan for you. They know the code, they know how to fill out the forms properly, and that's great. There's nothing wrong with that. In fact, we need that. However, they don't sit down with you and put together a plan. They just say, "Hey, I have a," and they say, "Hey, I have this tax filing that I'm going to prepare for you. You've given me the information. I'll send it in." And they don't really talk with you about putting together a plan. What you want to have then is somebody who is a tax planner, who sits down with you and reviews in detail your situation as a whole, and will sit down and talk with you about tax strategies that you can engage in. I'll give you a really good quick example here. I had one of my good friends who was one of the head tax advisors at our firm here. He talked with a client who had an LLC taxed as an S corporation. And then that LLC taxed as an S corporation was receiving, I kid you not, $2.5 million in 1099 income. The worst part about this is that he was taking the vast majority of this $2.5 million as a salary. The the S corporation election here, pardon me, I got tongue tied for a second there. The S corporation election actually allows you to differentiate between salary and distributions, and the distributions are actually taxed a little bit less. And so then what happened is this client of ours ended up on the phone with this friend of mine. Funny enough, his name is also Jeff here, pardon me. And he talked with Jeff, and Jeff said, "Hold on, you are taking literally." In this case, this person, this individual, was taking literally almost between him and his wife, a little bit more than $2.1 million in salary. in salary from this S corporation. This is a big problem. And so what happened then is this other Jeff, right? And he was telling me this after the fact. He said all I did was adjust the amount that he was taking in salary. And I said instead, you should take about $800,000 in salary instead. And so when he took that $800,000 in salary, making the change there, I'm not exaggerating when I say that alone pocketed our client $300,000 in tax savings. And what's wild about this was a 10-minute conversation. And this our client was so blown away. He said, "Whoa, whoa, 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 whoa. I could have saved that much in taxes just by making that adjustment to my salary." And again, my friend Jeff says, "Yes, yes, absolutely." And this our client who had been working with a CPA before. And so he went to his other CPA and said, "Wait, how come you didn't tell me about this?" And you know what his CPA said? His CPA said, "You never asked." That's a tax preparer, not a tax planner. So you want to work with a tax planner. And then the second principle we'll talk about here is we'll talk about, I should have just used the erase all ink, but whatever, is we'll talk about moving income. You can call it treating yourself as a business. You can call it tax shifting. You can call it whatever you like, or income shifting, pardon. But we're going to talk about moving your income where you get the best tax treatment. Because just taking most of your income as a salary, as you saw, is not going to give you the best tax treatment. So we want to make sure we move it to a place where we get more tax benefits. I'll give you an easy example here, and then we'll cover a couple more of these questions. So let's say, for example, we have a structure like the one that I showed you on the other side, where we have a Wyoming LLC. My handwriting is beautiful. I know, no need to comment there. And that Wyoming LLC owns in turn three other LLCs that all have rental properties on them. So say these all have rental properties on them. And so then these rental properties are making money for the LLC. That's fantastic. However, there are tax deductions that are available to these properties that you would not see elsewhere. And so we'll come over here and we'll have maybe a management company taxed as a C corporation. We'll set that up for you and we'll say, hey, this C corporation has more deductions allowed to it than does any other business entity. So we'll use that C corporation as a management company. It collects rent from the properties. It reimburses you for expenses that are tax deductible only under the C corporation and nowhere else. And then it'll send money back. Whatever's left over, like a good property management company. And this is, again, this is just a very simplistic, very reductive example here, but this really works. And what's great is that this is something that most other people just aren't talking about. I have CPAs, outside CPAs ask me all the time, why are you using a C corporation? And when I sit and explain to them, fortunately, especially the most recent couple of times I've talked with outside CPAs, they're very amenable to it. They'll say, "Why C corporation?" Some of you may have heard this before. They'll say like double taxation bad, and then I'll talk with them about it. And again, to their credit, especially this most recent one I talked with, they will say, "Oh, I get it. That's actually a really clever idea. I've never heard of that before, but that makes perfect sense." And then they go with it. This one I actually spoke with most recently, it was almost exactly word for word the conversation we had. He was frustrated. He's like, "Why are you using a C corporation? This is crazy." And I explained why. I said, "Well, our client can only take healthcare reimbursements as tax deductible through a C corporation. She can only pay for her education through a C corporation. She can only pay for these other things that are tax deductible through a C corporation. She uses a management company, funnels money back." And I could almost hear his grin on the other end as he's like, oh, I get it. Okay, we're good. Never mind. I totally see it. That's perfect. And then he took care of our mutual client and we were great. But it's something that other CPAs don't talk about because they're not tax planners. They're tax preparers. And so again, work with a tax planner, put your income where it's most tax advantaged. So those are a couple of principles. Now I told you I'd talk about trusts and how we use them, and I will right after we grab a couple of these questions over here. So So somebody is asking here, say we're looking at this structure here, and say we're looking at these LLCs that each own an individual property. And we have somebody asking, so hey, say just hypothetically there's a bankruptcy situation. Can these LLCs be foreclosed on or taken over in the bankruptcy? I'll tell you, usually the answer is no, but it really depends on the bankruptcy, right? It really depends on the kind, who the creditors are, and what happened. If you have a personal bankruptcy and you set up the LLC after the bankruptcy proceedings have begun, the judge is not going to be very friendly about that. They're not going to be very friendly about us hiding assets after we already know that the proceedings have begun. However, if we set up all of this ahead of time and do really well investing and then just fall on hard times after that, yeah, it could very well provide protection from something like that. So that's a good question. The answer is definitely possible, but it depends on the situation. Good question there. So, and then we have another question here. Um, yeah, this is a good one. So this individual asks a couple of questions here, saying, "Hey, this Wyoming LLC, if it provides such great protection, can we put bank accounts in this LLC, or even better, say brokerage accounts or investment accounts, and provide and have protection there?" The answer is absolutely yes. We have a whole slew of clients who that's the reason why they signed up with us is to say form a Wyoming LLC and to put their investment accounts, their brokerage accounts, and their bank accounts in there so that they have protection in the event of a lawsuit. So that's a really great question there. And then they follow up with how many LLCs can be owned by your Wyoming LLC? How many businesses can be owned by your Wyoming LLC? And the answer is, in theory, an unlimited number. Now, in practicality, right, we may want to start dividing things up, or if we get to, 20, 30, 40, 50 properties, we'll take a look at some more advanced strategies there. But in theory, an unlimited number. I have one client in particular that I've worked with on a couple of very complicated 1031 exchanges with them and their qualified intermediary, making sure everything looks good. And so I worked with this client, and I tell you about them specifically because they sold a couple properties, but I think it was 24 LLCs at one point. They've consolidated a little bit since then. I believe they had 24 LLCs underneath their Wyoming LLC. And so, yeah, you can have as many or as few as you like. Now, if we get to that point where you have 24, 25 properties, first, congratulations. But also, second, we'll have a more advanced conversation at that stage about what's going to be best for you for tax savings and for logistics and for protection. So, totally valid question there. Is the answer again is in theory as many as you like. But in reality, we'd want to start partitioning things off once we get to a certain capacity here. Great question. So I want to address here. So we get people, and Kendall mentioned this towards the beginning, but we get people talking about trusts and how do trusts work and when do we use trusts. And trusts absolutely have their place. And it's very true that trusts can provide protection if they're used properly. And it's also true that asset protection trusts or offshore trusts are a little bit overrated now as a magic pill, we'll say, or as a magic bullet. Stick everything into this one single trust, and then suddenly you're protected forever, and everything is, roses and unicorns and rainbows. That's not how it actually works in real life. However, there are a few very important places we will use a trust. So a living trust is vital here. So your Wyoming LLC might be owned by a living trust down here at the bottom, which provides a large part of that estate planning, making sure that you're planning for your future beneficiaries or your future heirs. But there's another kind of trust that we will recommend on occasion. We call them, not we call them as if we made them up. No, they're very real. But we use what's called a Wyoming Statutory Trust. So then what we say is this Wyoming statutory, I promise I can spell, I use the English language for a living. What it is it's a special kind of trust, as the name indicates, statute, that was made by statute in the state of Wyoming. And this it can be vital for tax planning if you're investing in states that have really high taxes for businesses like California. So in California, and I want to say this is a strategy that one of our partners, Clint Coons, came up with himself, and we've seen it work over and over again. Is in California, California taxes LLCs to the tune of $800 per year per LLC. So you can imagine that adds up. That adds up so quickly. But California has a decision on the books, a tax court decision with the Franchise Tax Board on the books that says statutory trusts are not subject to the franchise tax. So what we do then is we say, okay, in California, we might set up a Wyoming parent company like we do. But if you're investing in real estate in California, you might use a Wyoming statutory trust instead of an LLC. And as you can imagine, this adds up so quickly, the savings you can have through a Wyoming statutory trust, saving yourself that $800 per year per LLC, or sometimes more. The franchise tax, it's an $800 minimum. It can be a lot more than that if you're making a good amount of money. And the Wyoming LLC helps you avoid that. And we love it. The Wyoming LLC, I should say, and that Wyoming statutory trust. And again, this is a strategy that has just been out there on the open, but nobody had thought to use it for investments in California until our partner Clint Coons started doing it. And I have a couple of clients in California who this has made sense for, and it has just saved them so much money in taxes in California. So it makes a difference. And again, this is bringing it all the way back to the beginning, and then we'll open this up to the Q&A here. This is the most common mistake that we see with investors, with real estate investors, especially, is that they don't put together or they don't work with somebody who will put together a plan specific for them. They'll say, hey, I heard Jeff say an LLC is cool, and then they'll use an LLC, but then not file it properly, and then not make the correct tax election, and then not take care of it afterwards, and then they have no protection and they have no tax savings because of that. But instead, if you work with somebody who can put together a holistic plan, talk with you about your goals, and make sure everything is structured for what you need as you continue to grow. For example, if the Wyoming Statutory Trust is going to save you thousands of dollars on taxes, we will absolutely use it. But it's not for every situation. So that's the key, is the way that you save in taxes and the way that you protect yourself is work with somebody who will put together this plan for you, who will make sure that you're not investing in your personal name, make sure that you have that protection in court, and then put together a tax plan for you that will help you move your income to the place that it's most tax advantaged. So that's what we're looking at today. So thank you again so much, everybody, for joining. Those are the basic principles that I wanted to cover here. Now we'll open it up. Let's go for about, I know nobody wants to listen to an attorney longer than they need to. So let's open it up for about 10 or 15 more minutes-ish for question and answer here. I'm going to keep my screen up here being shared because sometimes it helps when we're answering a question to kind of illustrate or draw out the principle that we're talking about here. So pardon me. In fact, I'm going to grab a touch of water really quickly here.
Great, Jeff. Thank you so much. I'm just gonna, if you want, I'll let you just go ahead and take the Q&A and answer
Yep,
as you will, and then if you need me to jump in on any of them, help out, I'm happy to do that.
that'd be perfect. Thanks so much, Kendall. In fact, what maybe I'll ask of you is that if you want to stick around and ask questions, that's fantastic, and we'd love to have you stick around. I also want to tell you that we have a special offer here that we don't always give out, but we want to let you know that if you want to talk with me or one of my colleagues about your specific situation, we'd love to have you. So with the Protect Wealth team, we can offer this special, what we call a strategy session, where these normally go for either our hourly rate or about $1,000 flat to have a conversation with you about your situation. But for you, for attending, as a thank you for attending tonight, you get a free strategy session instead, where you talk with myself or one of my other colleagues about your situation. So I'll send in a link here in just a second, and you can use that to go ahead and sign up to meet with myself or one of my other colleagues and get your questions answered right away specific to your situation. So, Kendall, do you have that ready? That link that you can send in, or if not, I can
Yes,
grab
I'm
it
going
real
to add
quick.
that to the chat right now, everybody. So if you want to go ahead and click on that link directly, uh, you can go ahead and sign up for a consultation. Now, you guys know this is a fantastic thing, and one of the main reasons we bring on anyone from Anderson Advisors. So looks like we're having problems. Oh, there's a problem with that link there. Let me fix that, guys. But check that,
Oh,
click
good
that link
save.
in just
Yeah.
a second, and I'll have that ready for you. Listen, there's a somehow I defaulted there, but obviously, if you want to have some professional advice from someone at Anderson, you can tell Jeff and his team are absolutely professionals. And obviously, that's a big deal for anyone who wants to protect their assets. You know, do all the things: asset protection, tax strategies, estate planning. There's nobody better than Anderson, in our opinion, than working with Jeff and his team.
That's very kind of you to say, and we agree. And we love working with Protect Wealth here as well. And Kenley, I wouldn't be here if we did not wholeheartedly trust them and recommend them for everything they do. So thank you again so much for having us on. So I'll have Kendall send out that link there, but I'll grab some of these questions here. They're really good. So Christopher asks, and forgive me for looking off screen here while I read over the questions here. Christopher asks, hey, what about using something called a land trust? And yes, land trusts can be very helpful. They are similar to a statutory trust in some ways, and they can be very helpful for the right situation. But similarly to the statutory trust, is they're not going to be a magic pill, right? Or a one size fits all solution for everybody. No, land trusts are used for very specific situations. I saw somebody mention, and I'll actually address this question too, a primary residence trust as well. That's a term that we've kind of coined and used, which is literally, as the name indicates, a trust for your primary residence. And that primary residence trust is a special form of trust that we use to take your name off of the county records and provide some anonymity for you so that people cannot search you up on the county records and find where you live. With today's day in social media and canceling and things like that, can you imagine, your worst patient or your worst tenant or your worst client knowing where you live? Oh, good heavens, it's awful. So instead, we use that primary residence trust to take your name off of the county records. And a land trust or a primary residence trust are really good for these kind of specific situations, but they're not a magic pill or one size fits all. A good time for a land trust is in Florida. Like I mentioned earlier, Florida has that case, as precedent on the books, where the legislature actively said, "Hey, we want LLCs to provide protection." But then the Florida Supreme Court went against it, and they acknowledged that they were going against it. It's so wild. It's not that they misinterpreted. They're saying, "Well, we could see the way this could be interpreted this other way." They literally said, "Look, we see what they're saying, but we don't actually think that they meant what they said," and then moved off of it, which is just again so crazy to me. So a land trust might be really good in the state of Florida, or if we're dealing with a state that has high transfer taxes like Hawaii or New Jersey. So those are places where we might use a land trust instead. Oh, perfect. And I see that Kendall put that link up there. So thank you, Kendall. And come and jump on there and take a look and have a conversation with myself or one of my colleagues there to talk about your situation. So land trust, to answer Christopher's question here, land trust is really good for specific situations, but similar to the Wyoming statutory trust, it's not going to be a fit for everyone or a magic pill. Great question, though. And then this other person asks, "Hey, uh, what a what about if I have my family trust in my personal name?" Which is, if your family trust is not on public record, it usually doesn't matter if it's in your personal name or not. I'm not that worried about it. But for this specific person, they're saying, well, our trust is, or this other person's trust is a matter of public record because it's listed as the owner of a primary residence. Can that be changed? The answer is yes. Yes, yes, yes. Look, I'd prefer that we, purchase all of our properties in trusts or LLCs. However, I readily acknowledge, I'm realist about this, that it's not going to be possible every single time. So it's not too late. You can absolutely make a change to put a property into, say, a residence trust if it's a primary residence, or something else like that, like maybe a statutory trust if it's an investment property. So that is absolutely something you can do, and no, it's not too late if that living trust is the owner of record. Great question there. So I had, and I'm going to cover this one actually a bit out of order here just because it's on the same topic. So the person asks, well, what about a California property in a statutory trust versus a residence trust? And the answer is they are applicable for different situations. If it's your primary home, like your home, then we want that residence trust because it's carefully crafted to make sure that you still qualify for your homestead protection from taxes and your homestead exemption from taxes and your homestead protection and from lawsuits. So you want your residence trust if it's your primary residence. If it's an investment property, statutory trust is going to make a lot more sense because the statutory trust, again, by statute, by law, pardon me, in Wyoming provides a lot of protection because it's treated like a business. So if it's your primary residence, your home, yeah, residence trust makes a lot of sense. If it's your, pardon me, if it's an investment property, then your statutory trust is going to be better on that front. Great question, though. And Christopher asks, and this is going to, I promise Christopher's question here is not a plant, but this is going to give me a chance to show off a little bit some of our experience here. So Christopher asked, hey, so if you have an investment property, I'm going to actually draw this one out. So if you live in California, so an individual lives in California down here. So CA, they live in California, and they have, I'm just going to use a basic structure, so please don't hold me to this. They have a Wyoming LLC, and then they have a bunch of LLCs up here in other states. I just, using random states, let's just say North Carolina for fun. We have LLCs in other states in North Carolina that hold North Carolina properties. So Christopher is asking, will the franchise tax apply to these LLCs, this Wyoming LLC, and then these other states or LLCs that hold properties in other states? The answer is no, but yes. And so I know that that's such an attorney answer. Well, what do you mean, Jeff? No, but yes. I'll explain. The reason it's no, but yes is because on the books in the state of California, according to the statute, the franchise tax should not apply to any of those LLCs. However, the franchise tax board says we do not care, and they will tax you anyways. The franchise tax board operates under the assumption that anybody who lives in California who owns an LLC should be taxed in California. You could live in California and form an LLC on the planet Saturn, and California will still try to tax it. And the reason that California does this and is able to get away with it is because most, in fact, everybody to this point for California would rather just pay the $800 for their LLC rather than spend anywhere from $25,000 to $100,000 on a lawsuit fighting them over it. It's kind of devious if you think about it. And so this leverages our experience because I had somebody argue with me about that once. They're like, look, Jeff, the statute says that this should not be taxed. And I just said, I know what the statute says. I can promise you that if the franchise tax board finds out about this, they do not care. They will still tax you. And that's just from our experience that where that's leveraged in. And so that's just what we've seen in California. And yes, we have California clients, and yes, we as investors have California properties too. A few of us do. And so we know how that works. And so if you're a California resident, then you will just want to craft things in a different way. And you can talk with us and we'll show you a couple of different ways that you could potentially do this to prevent the franchise tax board from finding out about these LLCs. Because there are ways that we can say, hey, it will make it very difficult for the California franchise tax board to find out these even exist. And so if we make it difficult, if they don't find out it exists, then it makes it really hard to tax it, right? So, and this is something that you would need to talk with an advisor about your specific situation. So that's a totally valid question. The answer is they should not tax it, but they do anyways. So great question there.
It's scary. We've seen a lot of people, even on our side, and I'm sure you've seen this before, who invest in California, not living in California, but invest in California, real estate and otherwise, and they get that letter from the California Franchise Tax Board. It's
Yep.
absolutely unreal. I'm sure you fought a lot of those. We have too. It's kind of unreal.
It really does feel not real. And then Christopher asked a couple of follow-up questions, and he asked, well, how does California find out? And it's when you file taxes in California, they have forms where they will ask you, do you own LLCs in other states? And if you hit yes, then the form will also ask you, if you answered yes, does that LLC own other LLCs? And so they literally have that on the forms, and so they'll ask you to disclose it. And then if you do not disclose them, they find out later, and there might be a penalty. And so we just create ways for you to honestly answer, no, I don't own LLCs in other states, or things like that, right? So if that feels a little snake oily and loopholey, it's because it is, but it's because California has kind of forced our hand here, right? I wish there were a better way to do this, but because they are actively disobeying their own law, then we have to go back and we have to say, okay, we're going to get a little bit more creative about it than we'd like to. And that's where the statutory trust came from. So, great question there. I'm going to go a little bit quicker on some of these so we can make sure we get all of them. Um, so Ariel asks, hey, when you form a statutory trust or an LLC or something like that, who serves eviction notices? The answer is if it's a statutory trust, usually that's what we call the trustee, sometimes the manager. And if that's an LLC, it's the manager of the LLC. The LLC technically itself is supposed to serve it, but the LLC doesn't have hands, it's not a human. So then you say the manager will file that eviction for you. Good question though. And then we have a couple more here. Ariel also asks, well, what about the price to set them up? I'll tell you that will depend on your situation and how much work we have to do to get it. And so I'd feel a little uncomfortable telling you an exact price because your situation might be a little bit easier, so it might be lower, but also might be a little more complicated, so it might be more. But I will tell you, take advantage of that free strategy session so we can talk with you, sit down and talk with you about your specific situation and then tell you what it is that you need and sometimes even what it is that you don't need and then give you a full quote there. Understandable question though. Thank you, Ariel.
Yeah, and I will jump in on that too. That's why a
Yeah.
free consultation with an expert is so important, you guys. That link, I strongly suggest it. And here's why. I know we're always thinking price, but sometimes you got to remember, yes, that does matter. But here's how you want to think about it too: is not necessarily what it will cost you, but how much it will save you. Because we find over and over and again, and I'm sure Jeff, you can vouch for this. It's really how much Anderson's team can save you at the end of the day. It's generally speaking, like you mentioned, a lot of accountants, CPAs and whatnot are tax preparers, not tax planners. So when you have an actual plan, you're going to save a lot more. So it's a little more upfront cost, but for savings down the road, and that's typically the case.
Yep, that's exactly right. And that's why again, like exactly what Kendall said, making sure you talk with an expert who can put together a plan for you really, really will be the most important step that you can take there. So great point there. We have here Jan, who asked, and I apologize, Jan, or if it's Jan. I talked with somebody who had the name spelled that way. They pronounce it Jan. So either way,
It's Jan. We know Jan.
oh, okay, perfect, Jan. Well, good to see you, Jan. Jan asks, hey, can we use a living trust to essentially plan around trust taxation? If we set up one of these LLC structures and then we say, hey, this LLC is owned by a living trust, which absolutely is something we can help you out with. And yes, it does make a lot of sense in a lot of situations. Can we plan to have this living trust sort of change form or change shape so that this operation can continue after you pass away, but then not be taxed at trust taxation rates? I'll tell you the short answer on this is usually no. In fact, it's impossible to control something for multiple generations without a trust because every LLC, every corporation, every partnership, this is going to be awkward the way I'm phrasing this, but LLCs, corporations, and partnerships cannot control themselves what happens after their owner passes away. Ownership in a corporation, ownership in an LLC has to be passed on through a trust or through a will or through probate if the trust isn't there. And so there's no way to control it for multiple generations without a trust. And so these dynasty trusts can be remarkably beneficial in the right situation. And by dynasty, I mean a trust that lasts multiple generations. And it's also true that they don't fit every situation. A dynasty trust not properly formed very frequently is taxed to death because trust tax rates are so high. And so we have to make sure that whatever you are sticking in there is going to be able to sustain itself and then some because we cannot change it away from being a trust after one generation. Now, that said, I'll also add the side note that we again want to make sure we plan carefully for this because if we just say, hey, my three kids, I don't have any plan except that you're never going to inherit anything that I have, then but just receive distributions over time and said, believe me when I say that those three kids will at some point try to file a lawsuit to break into the trust and take the stuff out. so so what we want to do then is make sure if we're putting together a trust like that, that we have contingencies, we have reasons, that we have things for the trust to invest in, like charitable organizations. This is a, if we want to have something that lasts multiple generations, the combination of a trust and a charitable organization. We talked about that. Somebody asked about that towards the beginning. That's a great way to go there if we're trying to build something that will last there. So totally valid question. The answer is unfortunately we cannot tell a trust to not be a trust after one generation. It has to continue as a trust or else it just dissolves itself and the operations inside are left to the whims of the beneficiaries if it dissolves itself. Totally valid question though. Thank you for asking that. That's a great point there. Let me see here. Let me grab, we've got just a couple more here that I want to make sure we get to. Somebody says,
That's our
somebody
French
says
buddy,
here, oh,
Anonymous.
sorry, go ahead. What was that, Kendall? Sorry.
I said that's our French friend, Anonymous, right there.
Oh, I see. Well, perfect. Good to see you. So Anonymous asks, hey, can we open a bank account in the name of Wyoming LLC? The answer is absolutely yes. And it's actually pretty easy. You don't need some sort of special permission from an attorney or somebody to hold your hand there. I'll just tell you, you need to make sure with whatever bank or credit union you're going to that you talk with a business attorney. If you talk with just some ordinary teller just right when you walk in, they probably will not have any idea what you're talking about. However, if you instead talk with a business banker, they more than likely will say, oh, yeah, this is my third Wyoming LLC this week. Come right in. We'll get you set up. They take a look at your operating agreement. They take a look at the resolutions, which, by the way, we provide for you if you form an LLC with us. And then they will form it for you. And that's open the bank account for you. And that's great. And so just make sure you're talking with a business banker, just as kind of an anecdotal example. My brother-in-law worked at Bank of America, and for a time, so my wife's brother here, and he did a great job with his clients, but he was absolutely not located in Wyoming, and he had clients all over the country. But he, of his own accord, and I say this to illustrate for Anonymous's question here, but he, of his own accord, without any prompting from me, asked me, said, Jeff, what's up with Wyoming LLCs? I have my clients from all over the country who are telling me or asking me to open bank accounts for Wyoming LLCs, and I'm not sure why. And I explained to him why it was, and he totally got it afterwards. But I used that more as an illustration to say, like, no, you don't need somebody from Wyoming to open the account for you. No, you don't need, say, for example, one of us to be on the phone to tell the banker that we're going to sue them if they don't. No, if you talk with a business banker at your local credit union, or especially if this is a nationwide, a big nationwide bank or nationally known investment bank or things like that, they shouldn't even think twice about opening a Wyoming bank account if you ask them. Great question. Anonymous also asks, hey, if you have a statutory trust, how do we distinguish that from a revocable trust? I realize this is going to sound a little circular, but it's because we actually call it a statutory trust and we refer to the statutes in Wyoming. So we will say, hey, this trust is formed under Wyoming code section, blah, 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 right? I don't need to bore you with the exact citation, but it's in there. And we say, because of that, this trust is given special protections under the law. It is given all the same protections under Wyoming statutes as this, that, or the other, and we make sure we cite to all of that. And so the provisions that distinguish it are the ones that we refer to the statutory clauses that are in Wyoming. And then we also include a few clauses of our own that make sure the trust is treated more like a business entity than a living trust, so that it provides liability protection. So that's kind of the big distinguishing point there. Great thought there. And I hope this question's a little longer, so I hope you'll forgive me if it's a little awkward while I read over it here.
Yeah, it's a little complex and
Uh-huh.
specific to, sometimes it's hard to answer the ones that are specific, guys. As you know, we kind of have to give general advice, not specifics, as best we can,
So
guys.
So here Matthew asks, and this is a comment his Matthew specific question is not that common, but the general principle absolutely is. So he's saying, hey, if I have a property over here and I want to deed it into an LLC, am I going to pay the due on sale clause using a deed, right? And is my lender going to call my loan due if I put it into an LLC? My answer to you is no, they will not. But there's an asterisk on this. The asterisk to my no, they will not call that loan due is, but if you ask them, they will tell you they are going to, if that makes sense. We actively recommend that you do not talk with your lender on these loans because if you call into a lender and you call into somebody who just answers the phone and is here to answer questions, I don't mean this in a derogatory way, but it's just kind of a matter of fact that these people are not trained in nuance, they're not trained in special situations, they're just kind of pencil pushers. And so if you tell them, hey, I'm thinking about transferring my property to, they won't even let you finish the sentence and say to an LLC. You'll just say, I'm thinking about transferring my property, and they just slap that big red button, boop, the alarm goes off, and they're like, oh, they're trying to steal the property. Ah! And then suddenly you have a black mark on your account. And I apologize that that's a little exaggerated, but that is the idea, is that if you just call and ask your lender, they're not trained in nuance, they don't know what they're actually looking at, and so they'll just tell you no. They're trained to tell you no, you cannot move the property. However, if you move the property without telling them, and then you continue to pay your mortgage on time, and very importantly, so not just pay your mortgage on time, but the ownership interest in the property stays the same. And so what I mean by that is, if Malia, my wife, and I own a property 50-50, and we move it into an LLC that is also owned 50-50 by the two of us, and there's no functional change in ownership, then we have tens of thousands of clients of experience that know the lender will not, in fact, call the loan due. Now, if I have a property that I own 100% and I move it into an LLC that is owned 50-50 by myself and Kendall, then yeah, there might be trouble because for all the lender knows, Kendall, they haven't investigated Kendall, they haven't looked at his credit report, they haven't checked to see if he's a worthy borrower, and now he's getting in the way of their collateral. So in that case, yeah, that might be a bit of a problem. But if you own the LLC and you owned the property beforehand, nah, there's not going to be a problem. However, I will caution you, Matthew, if you have already asked the lender, if they've said no, give it a minute before transferring because now you kind of put them on alert and they are already grumpy with you. So give it a minute, especially if you have a really low interest rate. And I'll also caution you, Matthew, that putting a property into an LLC right before a 1031 exchange, make sure that you talk with your qualified intermediary about that because if you do not structure your LLC properly, that could ruin your 1031 exchange and you might just disqualify yourself from doing it for a year. So make sure you structure that LLC properly and you're working with a qualified intermediary or, not to toot my own horn too much, or an expert who knows what they're doing before you make that change. So great question there. So I don't see any other questions here. Kendall, did I miss anything that we're looking at?
No, I love it, but I think it just demonstrates the importance of working with someone who knows what they're doing. No offense to a lot of the attorneys and CPAs down the street, your brother-in-law, whatever. A lot of times they're very well-meaning, but they don't know what they're doing. And so we do see, I'm sure, Jeff, you see this every day. A well-meaning attorney or CPA tries to do a 1031 exchange and messes it up
Oh,
very
totally.
frequently.
Mm-hmm. Absolutely, absolutely. So I'll just say again, thank you everybody so much for joining us tonight. It's a pleasure to be here, and thank you, Kendall, for having us on. Click that link. We would love to talk with you about your situation and help make sure that you can protect your wealth and save thousands in taxes while doing so. So thank you again, Kendall. We really appreciate it.
Beautiful. Again, Jeff, thank you so much. We really do appreciate your expertise and time, the simplicity with which you explained that. Beautiful and brilliant. Thank you so much. We really do appreciate that. Everybody else, thank you again for being on tonight. What a great webinar. This will be on YouTube for a couple weeks here. And if you have questions, please click that link, schedule a free consultation. Jeff, does that go directly to you or to maybe a different advisors at Anderson?
It goes to myself first, but if I don't have availability right away, it will go to one of my colleagues as well, so we can make sure we get you in a timely manner.
And they're all great guys. You've met a lot of advisors at Anderson. Of course, you can get Jeff. You got the jackpot, but of course, they're all great and they're happy to help you. So definitely suggest you do that. If not, we'll look forward to seeing you at our upcoming Asset Protection Summit. Everybody, again, Jeff, thank you so much time. Have a great night.
Thank you as well. Take care, everyone.
Thanks, guys.